Okay, thanks so much. Sorry about that, everyone. So my usual introduction and disclaimer. Just a reminder, I do stop at this slide. I'm not your legal counsel. I'm not Orange Tree's legal counsel. This information we're going to talk about today is all educational in nature. I really do want you to check with your own legal counsel for any decisions you make about policy related to background screening. If you have questions about that, happy to take those questions as well. Let's see, yes, I can. Okay, and here's our agenda today. Those of you who join me every quarter, it looks a little different. Crazy, Heidi's doing something different. Not really, actually. Just we are in the first month of the new year, and so we don't have a ton of legislative activity. So what I thought I would do instead.
Sorry about that.
No, it might have been me. What I thought I would do instead was take an approach of looking at what's been updated since the last time we met, which was just in November. You do a little 2021 review. So look back at the whole year for significant changes under the topics that we're going to talk about. And then just sort of do a state of the state. So where are we at really across these sorts of topics? And we're still going to talk about ban the box. We're going to talk about salary history bans. We're going to talk about access, some court access issues that we saw over the last year, and then we're going to talk about drug testing, mostly marijuana drug testing. So those are our topics today, and you'll just see me kind of go back and forth through those topics with the most recent items to be thinking about, what happened last year and what we think will happen next year. So on ban the box, starting here, change, the most significant change here was at the federal level. A little surprising. We haven't seen a lot of activity there, but this actually comes out of legislation from 2019. It just had an effective date in 2021. So this was, if you all remember, I'm sure you wrote it down, the Fair Chance to Compete for Jobs Act of 2019. The effective date was here at the beginning of January of this year. And it is applicable to federal agencies and federal contractors, most federal agencies and most federal contractors. So those types of employers restricted from asking or prohibited from asking about arrest or conviction on the employment application. So fairly traditional ban the box language there. And then also are required to delay the criminal background check until after the conditional offer. So one of the more progressive or more recent ways that we're seeing ban the box or for fair chance acts being enacted, you see a little bit of both here in this federal law. Of course, it has exceptions. They call out positions that where consideration of criminal history is required by the law, federal law enforcement, national security positions, things like that. But if you are a federal agency, employer, or you have a federal contract, you will want to spend some time on the Fair Chance to Compete for Jobs Act from 2019. This is going to be a thing, huh? That's really the only change in ban the box that we've seen since we talked in November. Going back through 2021, I know I've seen people do this by date. It doesn't make any sense to me. So I did it alphabetically by state. Fun, right? Illinois, you'll remember we talked about this a couple of months ago. It was a significant change. They passed it in March. And it was immediately effective, which threw a fair number of employers into something of a spin. But basically, this legislation built on the existing ban the box legislation, which was in the Human Rights Act. And that prevents employers from asking applicants about criminal history on the employment application. So this new legislation here that went into effect in 2021 makes asking conviction records in employment decisions, using conviction records in employment decisions, a civil rights violation, unless you can show employer that there's a substantial relationship between that record or where the job, or where the record presents an unreasonable risk to property or safety of individuals, employees, the general public. If you are in Illinois going to be considering or using criminal history information in your employment decision, you'll want to have processes in place to ensure that you are looking at the length of the time since the conviction, the number of convictions, the nature and severity of the offense, and how it relates to the safety of others. The facts and circumstances surrounding the conviction, age at time of conviction, evidence of rehabilitation. Those should sound familiar, right? Very close to EEOC guidance related to doing an individualized assessment and factors to take into consideration or EEOC. And then special, again, for employers, a little bit tough requirement, but we are seeing it now in a few different jurisdictions. If you are using criminal history information in Illinois, and you have gone through that assessment and you have decided to move forward with making an adverse decision, you're required to document in that adverse notice going to the consumer about that decision, the basis for the decision. So what part, is it a substantial risk between the record and the job, or the unreasonable risk to safety of others or general public? So you have to document what that reasoning was in the adverse action letter. So Illinois. Louisiana, fair chance legislation here as well, had an August effective date and affects employers with 20 or more employees in the state. So pretty broad efficacy there. And it says employers can't consider arrest records or charges that didn't result in conviction. So if you have that in your background screening policy in Louisiana, take that look at that. For conviction records or non-arrest only records, again, employers need to be looking or inserting an individualized assessment into that decision and looking at whether the criminal history has a direct and adverse relationship on the specific duties of the job. So again, they're required to consider the nature and gravity of the offense, the time that's elapsed since the offense, the nature of the job sought. Also mentioned in the EEOC guidance, but actually these sound to me more like the green factors, right? That big case that predated the guidance, the 2013 EEOC guidance. So again, a trend, if we saw nothing else in 2021, it was continuation of that trend of codifying the EEOC guidance around doing individualized assessments and having factors that employers need to be thinking of or looking at or having in their policy when they're going to use criminal history information when making a hiring decision. Also, a little special part of the Louisiana law that is that the consumer or the applicant has the right to make a written request for any background check information used during the hiring process. So a little significantly actually broader than the Fair Credit Reporting Act or the federal laws requirement around adverse action or even around providing a copy of the consumer report. In this case, if you are an employer that does, part of the background check yourself, maybe you're checking social media yourself, this sort of request or that sort of information could be covered in this sort of request. So Louisiana employers just be prepared to be able to provide that information if you are doing something other than a consumer report through a consumer reporting agency for your employees in Louisiana. And this was also sort of a building on of an existing ban the box legislation in Louisiana. So that previous law only applied to state employment. This new Fair Chance Act applies to public employers as well. Employers still can't ask about criminal record information until after the interview. Montgomery County, Maryland. This one actually passed in 2020, but there was a 2021 effective date, so I included it here. Another case where there was existing ordinance or law on the books in Montgomery County from 2014. This added on to it. So now the Montgomery County statute applies to all employers with at least one employee in Montgomery County. Doesn't even have to be a full-time employee. And it redefines the employer to be more broad. So it includes a county employer, except a county employer that provides services to minors or vulnerable adults. And it prohibits inquiry into criminal history information until after the conditional job offer is extended. Again, exception there on that timing related to requirement to do something else under state or federal or local regulation or law. And it prohibits the employer from requiring the candidate to disclose an arrest that didn't result in a conviction, some first convictions for trespass, disturbance of the peace, or second-degree assault, misdemeanor convictions that are more than 3 years old, and of course, confidential or expunged records. Consumers or candidates are not required to disclose. Maine had a July ban the box legislation that passed, and that again became effective really quickly. So it was an October 18th, 2021 effective date. Again, we're seeing more and more of these ban the box legislation now applying not just to public employment, but also to private employers. Maine is not an exception to that rule. And employers can't request criminal history information on the job application, the initial application, or at any time before determining that the applicant is otherwise qualified for the job. Again, has exceptions where state or federal law, regulation, or mandate requires a criminal conviction disqualify an applicant for the position. Again, this is a case where this ban the box law sort of built on top of existing law. So there was a 2019 law already in effect in Maine. St. Louis, Missouri, January 1 effective date. Again, effective date was in the year, so we're covering it again quick today, but also applicable to private employers. They defined applicability to St. Louis employers with 10 or more employees. And it says employers cannot make an inquiry about a job applicant's history, criminal history, until after it determines that they are qualified for the job and have done an interview. Employers may not base their hiring decision on an applicant's criminal history unless they can show the history is relevant to the duties of the position. So again, hearkening back to EEOC guidance. St. Louis also has some advertising limitations. So if you are a St. Louis employer, do spend some time taking a look at that. Marcia, I'm seeing your question about is it St. Louis City or County? I have to admit, I'm not remembering off the top of my head. So let me look it up after the call, and I'll update the slides and include that clarification in the slide before Renew sends it out. New York City. So December 10th. So we had a late 2020 law passed, and the council made it applicable here in 2021. New York City, again, has had actually a fair amount of past legislation related to the Fair Chance Act. So this, again, expanded the scope of that law. There was a July 28th effective date. We all were sort of waiting with bated breath for regulation about the change or the expansion of the scope of the Fair Chance Act, because it wasn't terribly clear how they intended employers to implement it. We got that guidance, and it's tough. This is the one we talked a lot about this last year. I think I've covered it on almost every session, but basically this was the requirement to sort of bifurcate the background screening process for the New York City employers. So employers are limited in when and what criminal records they can consider, and timing is everything. So the requirement is that the employer do everything they can to generally qualify the candidate, including potentially, running the education employment verifications. And then once they believe the candidate is otherwise qualified, then do the criminal and driving portion of the background check. They actually, in the statute in New York City, redefined the definition, the sort of common law, what everyone assumes and knows to be the definition of a conditional offer of employment, to be an offer that exists only in order to complete the criminal record portion of the search. So employers have to take steps to ensure that they are not considering criminal history information until after that conditional offer. And they also need to be taking steps to ensure that they are not reconsidering education employment verification information that they previously were qualified under once that criminal background check is completed. It sounds complicated, it is a little complicated, but to give you an idea, the purpose or the reason, the council believes that employers, it's my understanding, the council believes that employers believe that employers sometimes withdraw job offers based on criminal history information, but they don't tell the consumer that. They instead say, oh, it was related to some other reason that you're not qualified. And so this is the way the council saw to implement a process that would require employers to fully qualify that candidate before they do the criminal background check, so that if they then withdraw the offer after the criminal background check, it's obvious and it's clear that the employer is doing that based on the content of the background, the portion of the background screening report related to criminal history. So all sorts of things go along with that, right? Make sure if you're an employer in New York City that you have procedures in place to do this. If you don't have a way to do this, make sure that you have procedures. If you don't have a way to get a separate set of reports from your background screening company, make sure you have procedures in place to stop the people doing the qualifications from seeing both parts of your background check until the right place in the process. Employers still need to follow the Fair Credit Reporting Act. They still have to follow New York state law related to consumer reporting. So they want to make sure they are making disclosures, getting authorization, perhaps doing an investigative consumer report disclosure with the first step of the background check, and then again with the second step. They're going to want to make sure that they have an adverse action process in place. Again, New York City already had a ton or a fair amount of regulation and even a special form if they were considering withdrawing an offer. So that special form process still exists for if the employer is going to make an adverse decision based on the criminal history information. So, and then on the adverse action side, they had the special form for the city, and then you've also got the New York City Fair Chance form process. And then don't forget, you also have an individualized assessment process required in New York City, which is what that form helps employers to do. So a number of steps in New York City. If you are in New York City, an employer, and you haven't looked at this yet, it might be a good idea as part of your 2022 New Year's resolutions to spend some time on it. Philadelphia, another city here where we saw some action. This was signed into law really early in 2021, became effective in April, expanded or updated the Fair Criminal Record Screening Standards, and it did a few things for employers. It expanded the definition of an employee. So it's no longer probably just the traditional direct employment relationship that is covered by those standards, but some of the less traditional versions that exist now, gig workers, independent contractors, the transportation industry, those sort of were targeted by the change of definition there. It expands the definition of the private employer as well. So again, that's an effort there to expand applicability of the standards. It previously applied, the standards previously applied only to applicants, and now it's been made clear that they apply to current employees as well. So if you're rescreening, if you're doing ongoing screening, these fair criminal record standards also now still apply. It does, good news for employers, expressly allow employers to consider pending criminal information under some circumstances. And then, but employers should be careful about using criminal history information in Philadelphia. Make sure you've got a policy that complies with the law here in that city. And then just remember too, Philadelphia had an existing statute related to employer use of credit screening and basically restricting use of credit history information in the employment situation, and it had some exceptions. And this update here in March of 2021 further limited the exceptions. So some of the automatic exceptions that existed before have now gone away under that new legislation there in Philadelphia. So that was sort of 2021 highlights. So what do we look like right now overall for Ban the Box? By my count, we've got 38 states, including DC, that have Ban the Box or fair chance laws. 17 of those are applicable to private employers. So that's a big jump, actually. I feel like it was more like 12 or 13 this time last year. So we saw some significant additional regulation for private employers over the last year. And then, if you think that it's hard to keep up with which states, the way that cities are and counties are legislating is perhaps even more, let's not say alarming, but more of a more homework for employers to be doing and looking at. By my count, again, 172 cities and counties have laws and ordinance related to Ban the Box, fair chance, or some other decriminalization that's going on. 21 of those applicable to private employers. So pay attention to those as well. As I know probably most of the people listening on the session today are private employers. So moving on to salary history. We didn't have any since the last time, no updates or changes there since the last time we talked. So we're just going to go right into 2021. Nevada, again, we talked about this probably in November, but that legislation passed in June and became effective October of 2021. Employers just need to be careful that they're not asking for salary history from an applicant for employment, that they don't rely on salary history to determine whether to offer employment or rate of pay, and that they don't discriminate by refusing to interview, hire, or promote based on provided salary history. So again, you'll start to see, or you'll continue to see salary history information going away from consumer reports. You'll see less of it as part of requests from former employers. They'll be less willing or less able or less interested in providing salary history information because of these salary history bans. Nevada and then Rhode Island was the other one in 2021. So again, passed in July, effective. We have a little time actually before this one becomes effective. I did double check it. It is 2023. So we sort of have a little more time for Rhode Island, but get ready. It makes it unlawful to pay an employee less than the employees of another race, color, religion, sex, sexual orientation, gender identity or expression, disability, age, or country of ancestral origin for comparable work. So we'll be looking at that comparable work standard, not necessarily just titles. A ban on employers' inquiries about or reliance on salary history. It says employers can't prevent employees from discussing pay. And there's a safe harbor. So employers, as you're looking at this, you've got a little bit of time before it becomes effective. If you do a project where you can document that you analyze pay and rectified any identifiable problems, it can create a safe harbor for you in litigation. So it might be worth your time if you are an employer in Rhode Island. So the state of the state here on salary history bans. By my count, we've got 19 states that have legislated now some limitation or restriction on employer consideration or use of salary history, another 9 cities and counties. So definitely seeing sort of a slow roll on this. We only, I think, had 2 over the last year that I could find. I think the rest of them predated that. I do sort of expect to continue to see this. Some point, most states will have something, and so employers will probably stop asking for it and stop providing it potentially, except in some accepted positions. So kind of look to see more of that happening in the coming year. Access. So access was big news in background screening in 2021. I do have an update. We talked about the last few times we talked about access issues we're having in Michigan. So just a little background here in early, it was early in 2021. The Supreme Court had implemented a rule change in Michigan, and they were basically removing date of birth and identifier information from public terminals, which was making it really hard for background screening companies and others to confirm and identify criminal records for consumers. So it was a sort of a year-long discussion with court officials in Michigan, and we did have an update here in very end of 2021 in December. The Supreme Court there adopted a negotiated court rule on redaction, and basically it addresses the concerns that we all had about the original rule, which would have barred displaying the date of birth in court records throughout Michigan. And it moves the effective date for the new procedure from it was going to be here at the beginning of January out to April. It is going to require a registration process for court researchers and potentially consumer reporting agencies as well, including requirements of proof of liability insurance for those parties in order to get public record information, and a proposed recurring registration process for us in order to access the record. So created a burden there. The court rules were about trying to protect privacy or identity, or using court records to potentially steal identity, and so they're looking to, by this rule, they're looking to limit that. And then by this negotiated rule, which will require some registration steps, they are looking to try to confirm sort of the legitimate business need of individuals that are going in and getting public records from the courts. So creates some burdens, but at least the sort of wholesale shut off of the ability to get identifying information on public records is at least, we hope, off the table. We are still seeing slowdowns in Michigan. We are still seeing courts that are implementing the rule in the way that it was previously discussed, and they don't seem to be holding off on this April timeframe. So working with those courts directly with our public records research runners when that happens, working with the PBSA when that happens to try to get some change going on there. We're also in Michigan just seeing a ton of closures related to COVID. So the two things going together are not a good combination right now, but more to come on Michigan here. As I mentioned, we've got an April implementation date for that rule. So we'll try to give you an update in the Q2 compliance update. The other state that we spent a fair amount of time talking about related to access in 2021 was California. So California adopted a rule that prohibited the display of or publication of date of birth or driver's license information on court records, calendars, or registers of actions. Again, historically, we need date of birth, we need driver's license. There are significant identifiers that we use to confirm identity before we report records on our consumer reports. So the rule came out of a lawsuit called All of Us versus Hamrick, and the court did a statutory interpretation that held that date of birth and driver's license information could not be either displayed or published. There was an appeals process and an amicus brief process, and then in September the Supreme Court confirmed that they would not review it. So courts in California have continued redacting date of birth from both their online and public access terminals. Doesn't mean the date of birth has disappeared or gone from the record. It just means when we have a possible match, we have a, let's say, a common name, we have a name match, and we then have to submit requests to confirm or get additional identifiers from the court record to the clerks. So it just inserts a ton of delays. Clerks are, as you can imagine, already understaffed. COVID is impacting that significantly. So expect delays in California. We need to get clerk's assistants to verify dates of birth or driver's license numbers. They'll continue to be difficult in California. Also of note in 2021 related to access, just the impacts of COVID. You've got rolling closures, and we hear and talk about illness related to COVID causing closures, shortness of staff, but really it's just staff shortages in general. We are all living through significant staff shortage, the inability to fully staff, and courts are not different than that, right? So we're seeing court clerks, groups of clerks that are short-staffed. We're seeing positions going unfilled. We're seeing courts where they just simply close. There's no clerk there for that week because somebody had to go on vacation or someone was sick. So all in all, considering all the things that could be happening with COVID right now in courts, I think we're doing pretty well. I think I counted this morning and there was about something less than 2% of courts showing a delay in the ability to get criminal records, and that includes basically all of the state of Michigan. So could be worse, but do expect to continue to hear about this. Courts are, like I said, as short-staffed as we are. They are turning over positions. They are hiring people that don't have as much experience as clerks did 3 years ago, and things are just taking longer. Oops, I kind of went right into this. Likely to continue this year, right? I don't really see that letting up too much. Hopefully, as we see closures, they'll reopen, or as we see delays, they'll those timeframes will be shortened. Other states and courts moving towards data restrictions on the horizons for 2022. I put a question mark there. I think it's not unlikely. Unfortunately, it's political. And so I think in the current the current political climate, we're likely to see these sorts of suits or urging of courts to change rules to continue. I think mostly it's just a communication issue, and communicating to the courts. We understand the identifiers aren't just out there because it's fun or easy. We really do need this information. Employers really do need this information in order to confirm records belonging to their applicants, so they can make hiring decisions that take into consideration what they knew or what they should have known about that applicant's history. So,
Heidi, sorry not to interrupt you. We have a few questions here. Do you mind if we just take a quick pause to answer some of them?
I don't mind. I've got about, I think, 15 more slides to get through drug testing, so it's up to you.
We'll just do a quick answer for these, and then we can also follow up with you after the webinar to provide more details on these questions. So we have a question from Jamie. Inside your system, if we have a standard background that isn't accepted in a state, is the system smart enough to omit these areas?
Inside our system. I think you're talking about ban the box, I'm guessing. In general, those statutes are related to the timing of the criminal background check and or when you make the inquiry. So we don't have knowledge of where you are in your processes related to whether or not you've made an offer. So employers do need to be cognizant, be thinking about timing and when is the right time to submit the background screening order to Orange Tree from a ban the box standpoint. I think that answered that question, but we might need to just ask for clarification offline.
Yes, sounds good. We'll follow up with you just to provide more information. A question from Michael Matthews. They're in California. When someone gets caught in a court-assisted search, it's basically certain they'll go to work somewhere else, and they are out all the time and cost invested in trying to hire that person. I don't think that was a question. Sorry.
Yeah, California is tough.
And then for the sake of getting through the rest of the webinar, everyone else that has a question, we'll just follow up with you and provide the answer. Thank you.
Yep, sure. If I have time after I get through drug testing, we can circle back to. Things happening recently in drug testing in New York, the state of New York here, the Department of Labor published recreational marijuana guidance in October. And so it's in the format of an FAQ. So if you're a New York employer, do take a look at that. The facts or FAQs are intended to assist employers in navigating the Marijuana Regulation and Taxation Act, which went into effect in March. And it does identify specific articulable symptoms of impairment. It covers drug testing of employees. It covers drug testing for use or possession during work hours, workplace policies, and applicability. So if you are a New York employer, do take a minute to take a look at those FAQs, some interesting and hoped for information there. In Pennsylvania, a reminder again, this happened here end of Q4 in 2021. Pennsylvania had an interesting medical marijuana case. It was Reynolds v. Willard Manufacturing. It was state action for discrimination. Let me see, I don't have my slide notes here, but if I can just remember, I believe what the facts of the case were, the candidate was a medical marijuana card holder in the state. They were pre-employment drug tested, and they received a medical review interview based on a positive drug test result. They told the medical review officer about their medical marijuana card, and the medical review officer reported the drug test result to the employer as a positive. They did not share information with the employer about the applicant or the candidate's status as a card holder. The employer withdrew the job offer or terminated employment, and then the applicant told the employer that they were a card holder. The employer decided not to reconsider their decision, and then this case was brought. It got removed from state court to federal. And in this case, the court found for the employer. They said the Pennsylvania Medical Marijuana Act indicates that it prohibits discrimination based solely on the basis of such employee's status as an individual who's certified to use medical marijuana, and does not explicitly or implicitly protect against discrimination on the basis of a drug test result. Good outcome for an employer, good outcome for employers in Pennsylvania in general, but a little bit fact specific. Things happen in exactly the right order for this employer, so take that into consideration as you're taking a look at this case. More specifically in Philadelphia, again, recent update, city ordinance went into effect, so January 1st here in 2022. It applies only to pre-employment drug testing, and it severely restricts the employer's ability to test prospective employees for marijuana. So this is one of sort of three now cases where the legislation or the ordinance specifically goes after the employer's ability to test Instead of in other cases, in other state statutes and local ordinances, the language is usually more around the employer's ability to use a positive test, like a positive test result for marijuana. And Philadelphia here, a little more restrictive in that it limits the employer's ability to test. And of course, it does have exceptions, but they are unlikely to apply to a lot of employers. So if you're in Philadelphia, it's a busy year, and take a look at the drug test legislation, or the marijuana drug test legislation there. Alabama, so going back into 2021, more broadly, Alabama, they had legalization of medical marijuana went into law in May of 2021 for adults and minors with certain conditions under a doctor's recommendation. It is effective sort of immediately in May, but probably won't get up and running because it will require a regulatory scheme until about mid of 2022. Employers aren't required to accommodate use and can refuse to hire, even if it's being used legally. And employers can still create drug-free testing policies that exclude medical marijuana or require notification of use. So sort of a more employer-friendly version of a medical marijuana law in Alabama. Arizona, this was a voter initiative, and it did pass, but it does require a regulatory framework. Again, added recreational marijuana to an existing medical marijuana program. And so now individuals 21 and older can possess, consume, and transfer marijuana, and employers are, good news for employers, not required to accommodate use, consumption, use, consumption, possession, transfer, display, sale, cultivation in the workplace. So employers can still be creating policies around marijuana use in the workplace, and employers aren't restricted in their ability to prohibit or regulate conduct permitted under the proposition while on property, and driving while impaired is strictly prohibited. Connecticut, another 2021 update signed into law June of last year, legalizes the use and cultivation of recreational marijuana for individuals 21 and older. It included some language to expunge some past convictions for possession. Was effective in the middle of the year, but again, probably there won't be a program available for that until mid-2022. It does still allow employers to maintain a drug-free workplace policy and implement practices prohibiting possession, use, consumption. It does have some exceptions to that. A reminder, as always, for drug testing, policy is key, right? So for every one of these that I've talked about, so far, with the exception of Philadelphia, having a policy in place still allows the employer to limit, to test for marijuana, limit employee use in some ways. But again, if you don't have the policy to back it up, it's not going to matter, right? You're going to be in trouble anyway if you're testing and you don't have a policy related to it. So make sure you've got a strong policy. That's Connecticut. Montana, another recreational marijuana law, and this one allows individuals 21 and older to participate in a marijuana market. And then there's two initiatives in Montana. Employers are not required to permit or accommodate in workplace or on work property. Again, you want to have that in your policy in Montana. Employers can still take disciplinary or adverse action for violation of the workplace drug and alcohol policy, and can still deny employment based on violations or based on working while intoxicated. You can see, again, you can hear all of these similar. The issue is going to be workplace, if somebody, the policy still probably allows the employer to take adverse action or to prohibit use in the workplace. But you're going to see it's going to become more and more important to be able to document that use, to be able to identify that use, especially as we see states and cities legislating against testing for it. In New Jersey, recreational marijuana law passed, another voter initiative, and then subsequent legislation implemented the program. It went into effect in August. Actually removes marijuana as a Schedule I drug and makes it legal for adults over age of 21 to use. It does protect employees. Sorry, in this case, this is an employee protection, not an employer protection. So it protects employees who engage in off-work marijuana use from adverse employment action taken on the basis of that use, and limits the employer's ability to act on the basis of a positive marijuana test after employment is started. Focus there in New Jersey maybe on your pre-employment testing. Again, employers can still have a policy. They can have a drug and alcohol-free workplace policy. They don't have to accommodate use, consumption, being under the influence, possession, transfer, display, transportation, sale, growth in the workplace. Employers can still have policies prohibiting use or intoxication during work hours, and does require the legislation required an impairment recognition expert. And there was guidance expected. You can just maybe see it at the bottom of the screen. Guidance expected to creating a program to certify someone to be an impairment recognition expert. We were waiting for that certification when we talked in November. We are still waiting for it. So the guidance came out. It did not include the program to create a certification for that sort of professional. So the requirement to do that examination for impairment is still on hold and abeyance pending that creation of that program. Oh, I'm like at 1 o'clock. I think I have a few more slides. Maybe I'll just skip through them and we'll get to sort of the state of the state. Just quickly to wrap it up here. Right now, by my count, 36 states plus DC have some sort of medical marijuana program. It was easier for me to type in the states that don't. So you see those 3, and then we've got about another couple of handfuls that have some sort of CBD or low THC program. States that have recreational marijuana programs, 18 plus DC. Again, we usually see these happening in sequence, right? First, the medical marijuana program is implemented or legislated, and then we'll see recreational marijuana legislation happening or voter initiatives happening after that. Currently, in the current session, we're just at the very beginning, but we're already seeing many bills being introduced or progressing. Again, recreational legalization, decriminalization measures, medical marijuana measures in states that don't have them mostly. We expect to see more of that. We expect to see more states explicitly exclude marijuana testing for pre-employment, like Philadelphia, New York, Nevada. Again, there's exceptions there, but those are significant changes. And then we'll also expect to start to see more call or more requirement for other ways of testing, documenting, showing impairment, as opposed to just drug testing or fitness for duty drug testing. That's all I have. Sorry to go over.
So everybody, we know we have questions. We have those questions logged. Renew has been cataloging those, but perhaps even sent a couple of responses, but we will follow up with all of you. If you have additional questions based on some of the last couple of charts, please let us know what they are, and we will definitely follow up with you individually. Oftentimes in a compliance topic, it can actually be a bit more helpful to do so because there's a lot of it depends, and it can get into your business policy for us to really give you the insight and direction that you would most appreciate. So without any further ado, thank you for attending today's webinar. There will be an email with an opportunity to give us some additional information about how we can provide interesting or content that's interesting to you this year And so thank you very much in advance for your participation. Have a wonderful day. Take care, everybody.
Thank you.